Mr. Butler, I should tell you, I remembered what it was about Calabar Properties. It was one of the very few cases in which a decision by Judge Stab was considered by the Court of Appeal and was rightly upheld. Judge Stab was the best of the old official referees, but it was very rare that an official referee decision got into the law reports, even by way of the Court of Appeal. So it wasn't something, it was something odd because of that.
Yes.
But well, there was nothing odd about the decision.
He's a legendary name, although yes. I fear I never had the opportunity to appear.
My first ever court appearance.
Ah, well, yes, that does tend to leave a mark.
It does.
My Lord, with the benefit of a bit of time, I'm going to limit myself to 3 further points, if I may.
Yeah.
And I hope not to take up more than about 10 minutes of your Lordship's time. The first point is this: at the risk of going over old ground, it was put to me this morning that a developer who is required to pay a diminution in value claim, but then subsequently is ordered to do the works, or does the works, is exposed to an element of double jeopardy. That is a valid point, but the corollary, of course, is that the delay in doing the works, if the developer is not ordered to compensate an owner who has divested themselves of the property at an undervalue, would leave that owner potentially without a remedy. So if there is an element of double jeopardy, we say it's of the developer's own making, and it's not a reason not to allow somebody in the position of the claimants in this case to maintain a diminution in value claim. So that's the first point. The second point just requires us to look at the judgment of His Honour Judge Keyser, if I may, which we haven't really done, in fact, very much in the course of this morning. But if I can just take you to one central point, paragraph 22. This is page 26 of the core bundle. Paragraph 22 is where he rejected the diminution in value, or the, perhaps I should say, using the terminology, the capital losses claim in the schedule of loss. And he said, it was submitted by Mr. Wilson, this head of claim fell within 25.2.1 of the POC. I do not agree. Whereas there are claims that leaseholders can properly advance under 25.2.1, this is not one of them. He goes on to say the capital losses are spurious. They're seeking to claim damages representing alleged diminutions in value of the flats at specific past dates on the basis of defects identified at those dates, despite the fact that they retained the flats thereafter. Flats were not sold on those dates, or indeed at all. Now, I just wanted to make the point that the selling of the flats is not on the authorities a trigger for a diminution in value claim. And there are 2 authorities in the bundle which support that point. The first, I'll take you to them very quickly if I may. The first is the case of Strange and Westbury Homes, which can be found at page 156 of the authorities bundle. A decision of the Court of Appeal, neutral citation 2009 EWCA Civ 1247. Now, the background to this is a case in which, in fact, my learned friend appeared. It was a breach of contract claim in which it was common ground that brickwork to certain residential properties was damaged. The claimants claimed damages for breach of contract under 3 heads. First of all, the cost of remedial work. Secondly, a residual diminution of value claim, a blight claim, effectively. And thirdly, inconvenience and distress. Now, I recognise straight away that this was a blight claim, which the present claim is not, so there is that point of difference. But I would just like to take the court to one passage of this paragraph 16, which is at page 164 of the authorities bundle. Where one of the challenges made by my learned friend was that awarding a residual diminution in value following the completion of remedial works is possible but should not have been made on the facts of that case. Sought to distinguish the case from a commercial property case, and it was said that wasn't a proper or principal basis for distinction. And then in the last 8 lines, the Court of Appeal say, nor can I accept Mr. Singer's submission that it was not open to the judge to award damages under that head because the claimants apparently had no present or fixed future intention to sell their properties. The fact they did not intend immediately to sell the properties did not mean that the assessment of diminution in value involved a hypothetical exercise in guesswork as to what the market conditions would be at the time when, if that time did occur, the claimants came to sell their properties. So insofar as it's said that the fact that Mr. and Mrs. Wilson had not sold their properties at the time when the defects occurred is fatal to a claim for diminution in value, in my submission, that's incorrect.
Yeah.
So even if that criticism could be made of the schedule of loss, that it's not specific about timings, that's not a fatal bar, in my submission, to the advancing of a diminution in value claim. That's the point.
Yes. I mean, that is, I mean, obviously, this was a blight claim. But
yes.
I mean, that goes back to London Corporation and the principle that you don't have to sell in order
Yes.
to crystallise the loss.
Yes.
I think, to be fair to Judge Keyser, though, at paragraph 22, I accept at once that it's not very well expressed, but he's dealing with this specific claim and the diminution in value claims, if that's what they are, that were being advanced, as it were, along the way. And he was making the point that, well, they weren't sold at that point, so loss didn't crystallise then. So I think he was making a temporal point by reference to the 3 dates that are identified. But speaking for myself, I would certainly agree with the general principle that, and I think I put that right at the start of this morning, that you can have a claim for diminution in value even if you don't sell. It's just usually in a building case that's calculated by reference to the cost of remedial work.
Yes, well...
And that then brings us back into what we were talking about this morning.
Yeah, well, my lord, I'm perhaps at risk of labouring the point in that case. I respectfully agree with that characterisation, but it does feed into the efficacy and the validity of the schedule of loss. The mere fact that there isn't absolute clarity about when that loss is said to have crystallised is not fatal to it. If those defects, in fact, had the effect of diminishing the value of the property, that is a viable claim to advance. My lord, just to the same effect then, and I don't need to dwell on the point, I'll just take you to the passage in the other case I wanted to refer to, which is Harrison.
Yeah.
And that is at tab 17 of the authorities bundle, beginning at page 296 of the bundle pagination. And the paragraph in question is paragraph 2, I beg your pardon, that's a Court of Appeal decision in Harrison. The first instance decision in Harrison begins at page 175.
Yeah.
And the passage, very quickly to take you to, is paragraph 277, which is found on page 233. In Harrison, just by way of very swift summary, Harrison was a claim for damages in respect of freehold property which suffered from defective piling. And the essential issue on quantum was whether the proper award was diminution in value or the cost of repairs.
Yeah.
Now, the judge awarded diminution in value, and the third of his reasons at paragraph 277 was that, as many of the claimants stated, they wished to sell their homes. They hadn't sold, and there was no firm evidence of when they would sell, but the judge held that the reality of the situation was that the claimants would sell their existing houses and use the money to move elsewhere, and that was one of the reasons he gave for awarding diminution in value. And that supports the point, but it may not be contentious, my lord, that diminution in value is an available remedy, notwithstanding the absence.
Well, it was in that case because they thought they might sell, but we know that here the Wilson parents didn't sell.
They didn't sell, but they disposed of the property.
So that goes back to that point.
Yeah. So, my lord, that really is the second point, that His Honour Judge Keyser at paragraph 22 fell into error in holding that simply because there had been no sale at the dates referred to in the schedule of loss, no claim for diminution in value could be advanced. And the third point I just wanted to make was this, and again, Your Lordships will, I hope, forgive me if I am making a point Your Lordships already recognise. We've cited the authority of Kim and Park as authority for the correct approach that court should take if confronted by a pleading which it considers to be defective and which is the subject of an application to strike out. And I would just like, if Your Lordships would indulge me, to take you to page 173 of the authorities bundle, which is paragraph 40 of Kim and Park, just to see how the matter is put there by Mr. Justice Tugendhat, and how it's replicated now in the White Book. Where the court holds there is a defect in a pleading, it is normal for the court to refrain from striking out that pleading unless the court has given the party concerned an opportunity of putting right the defect, provided there is reason to believe he will be in a position to put the defect right. And the simple point here is we say His Honour Judge Keyser did fall into error insofar as he recognised that there were potentially valid claims. It was appropriate for him to give Mr. Wilson the opportunity to put the pleadings right rather than move straight to a strikeout. So that again is... Well,
he did in relation to the rental.
There are a couple of instances in the judgment where he says...
provided that there is a reason to believe they will be in a position to put the defect right.
Yes.
We tend to read that as saying, show us your draft.
My Lord, drafts, again a point I made this morning, tend not to be available on strikeout applications. Litigants turn up to defend their pleading as it stands, and in circumstances where the court considers that there is a vestige of a claim but not one that has been properly put, the usual course is, the normal course is to give time to amend, and we simply say His Honour Judge Keyser fell into error by not doing that here. Okay. I just wanted to show Your Lordships how it's put in that paragraph, which in my submission represents the law. My Lords, unless I can assist with anything further, those are my submissions.
Thank you very much. Just give us a minute. All right, thank you very much. Mr. Singer, we needn't trouble you. We see this as a relatively straightforward debate about the schedule of loss, and we consider that the schedule of loss in this case was struck out by Judge Keyser, having thought about the various points, and we can see no basis on which we could find that this schedule of loss was not properly struck out by the judge. So for those reasons, we would dismiss the appeal. And therefore, Mr. Singer, we don't need to hear from you. We will obviously provide our reasons. That will be in the way of effectively our draft judgments. We will send those to you in draft so you can check our typographical errors, spellings and the like. My clerk has a list of the people to whom the draft will be sent. The draft is confidential, as you both know, and therefore must not be referred to or read by anybody other than the people on the list, and any breach of that is a contempt of court, as I'm sure you're both aware. Once we have had back from you the corrections, at the same time it would be appropriate for you to agree the order that you want us to make, and if you can't agree the order, then to provide an order with two different coloured versions of the bits you don't agree, and very, very, very short written submissions on the points on which you disagree. So that's the result. We'll produce, as I say, the written judgments as soon as we can. Thank you to all of you. There's some quite interesting points in the mix, and we will deal with them to the extent that they're relevant in our judgments. And Mr. Butler, I think the only thing I need to say is to repeat what I said this morning, that you did a very good job battling for the schedule of loss.
Well, Your Lordship is very kind, thank you.
Thank you very much.
Thank you, my Lord. Just, if I may indulge for one moment, having not said very much at all, for which I am, of course, extremely grateful.
We're dismissing the appeal.
Yes.
So
there is a cost schedule, which it might.
I haven't seen the cost schedule.
Well,
So
it was sent to your Lordship's clerk.
we'll deal with all of that. We'll deal with all of that when we
Yes.
deal with the order.
Yes, and if I might perhaps just mention one point for the purposes of the draft judgment that you're going to make, and maybe you weren't going to say anything about this at all, but for the sake of form, just so your Lordships have this point, there have been some criticisms made of delay on the part of my clients in doing remedial work.
That won't be part of the judgment.
I'm very grateful.
Because that's not a point on which we have formed a view, which I think was a point I put to Mr. Butler at one point this morning.
I'm very grateful. I'm sorry to have
Right. Okay, thank you all very much.
Thank you.